Good afternoon, ladies and gentlemen. When I first saw this case, my initial thoughts were that Stephanie had no case, as what she had suffered was acute mental trauma, which we know is not an outright psychiatric illness. The most relevant precedent to use to help verify if Stephanie has a claim is the case of Wilkinson v. Downton. The case of Wilkinson v. Downton arose from a practical joke that went wrong, similar to Stephanie's case. It is also known as the standard comparison of the tort of intentional infliction of emotional distress and is classified as an intentional tort. For the sake of not repeating myself many times, I will shorten it and say IIED instead. According to Wilkinson v. Downton, Michael will be liable for damages as the information he conveyed to Stephanie was untrue and he knew that it was, and it was this information that resulted in her distress. In Wilkinson v. Downton, the result of the practical joke had resulted adversely for the defendant as Mrs. Wilkinson became so ill her hair turned white and she suffered severe psychiatric illness. She did recover damages for the emotional distress that she suffered because of IIED and because the joke that was told to her was considered fraudulent misrepresentation. Applying this to Stephanie's case, she too would be able to claim damages for this. For Stephanie to claim more damages for her mental state, she needs to prove that she is suffering from a psychiatric illness. Lord Bridge stated that the first hurdle a claimant faces in claiming damages in this situation is to establish that he or she is suffering from more than just grief, distress, or any other normal emotion, but suffering from a psychiatric illness. As her lawyers, we should bring Stephanie for further medical tests to see if she has developed any other psychological injuries that have come from her acute mental trauma. In Basugo v. Logo Limited, the president of the Republic Equatorial Guinea claimed that the defendant, the leaders of the failed coup, were trying to kill him and his family, which resulted in him suffering distress and thus bringing a claim under the precedence of Wilkinson v. Downton. The claim was refused because he only suffered from distress without any psychiatric illness. The Court of Appeal was not prepared to accept distress as part of a new tort IIED. Though the court did not rule out the role of IIED in common law in the future, it did say that what the claimant suffered was harassment and that he could seek protection from the Protection from Harassment Act 1997. Alternatively, Stephanie could use this as a possible defense too. The possibility of recovering damages for mere mental distress is left open for change, as Lord Hoffman had observed in Wainwright v. Home Office, and he wanted to reserve his opinion on whether compensation should be awarded if there was a genuine intention to cause distress. More recently, in Rhodes v. OPO, the Supreme Court noted that Lord Hoffman did not answer that question. However, there was common consensus among all in court that for damages to be claimable, there should be a recognized psychiatric condition. Why should the courts adopt IIED as a tort and mere distress be sufficient for compensation? Firstly, defendants should be held accountable for their intentional misdeeds and rather than their unintentional and accidental acts. Secondly, insisting on recognized psychiatric injury rather than just mere mental distress leaves a loophole where the defendant can act in such a way that causes mental distress rather than psychiatric injury. Thirdly, if mere distress is enough to prove for compensation, claimants will be able to recover that under the tort of IIED, as currently defendants are claiming that they had acted negligently rather than intentionally, thus bypassing the tort of Wilkinson v. Downton. The acts that Michael could have done to have triggered IIED are conveying false information to Stephanie and knowing that information was false, making verbal threats, and doing some physical act that had the intention to inflict harm on her. Michael had given Stephanie false information, as similarly seen in Wilkinson v. Downton, where both defendants in this case had known that the claimant's significant others were fine and did not suffer such an injury. A possible defense of Michael would be following the case of CVD, where the defendant videoed a 10-year-old pupil and his schoolmates when they were showering. This incident caused the claimant to have emotional distress, but however, this was not claimable. The defendant also then happened to pull down the trousers of the claimant and look at his genitals. This second incident caused the claimant to suffer psychiatric injury, which rendered it a compensable act. The law insists that there be a recognized psychiatric injury to claim compensation, regardless whether the defendant's actions were lawful or unlawful, despite it falling under Wilkinson v. Downton. Therefore, Michael can defend himself by saying that he did not mean to cause Stephanie physical psychiatric injury, but merely make her emotionally distressed. However, under the case of Javier v. Sweeney, where it was seen that the claimant could recover damages under Wilkinson v. Downton as the defendant conducted himself in a certain way and had the intention to blackmail the claimant and commit a wrongful act. This calls Michael's intentions into question. His intentions, though not explicitly found out like in the case of Javier v. Sweeney, can be seen through his words and conduct. According to Rhodes v. OPO, where the Supreme Court held that the tort of Wilkinson v. Downton consisted of three main elements: the conduct element, mental element, and the consequence element. The conduct element requires conduct that has no reasonable excuse, and the burden of proof is on the claimant. The mental element requires an intention to cause physical or mental harm or emotional distress. However, the Court of Appeal judgment held that recklessness was sufficient. Finally, the consequence element requires evidence of physical harm or recognized psychiatric illness. Now applying these elements to this case, the question whether Michael's conduct and behavior was reasonable and intentional comes into question. He was red in the face, out of breath, and banged the door to wake Stephanie up, thus fulfilling the conduct element. By mentioning that the police would be coming by to talk to Stephanie, fulfilled the mental element, as it is common knowledge that the police coming to speak to the victims' families mean that they are delivering bad news, fulfilling the key mental element that makes her fear for Ahmed and feels emotionally distressed. Stephanie, being emotionally distressed, fulfills the consequence element. Thus, she can bear the burden to prove that Michael's words and conducts were not justified for a mere joke as he claims it to be. Michael cannot have said that he did not mean to act in that way, as according to Wright J. in Wilkinson v. Downton, the defendant had committed an act in such a way that was intended to produce some kind of effect. Now comes another question. Would Stephanie have suffered that type of distress had it not been for Michael's action and conduct? What if someone else told her that joke or said the same scenario to her? Michael's conduct is the defining point here. When we tell a joke, we simply say it. Michael seems to have gone out of his way to make an entire act to make it seem believable to a point that Stephanie would not have doubted him at all. Thus, to hold people like Michael who believe that it is all right to conduct themselves in that way, liable and accountable for their unreasonable actions, the court should adopt the new tort of IIED. However, presently, without the courts adopting IIED as a new tort, the emotionally distressed Stephanie has no claim under IIED. By allowing IIED to be a new tort will result in people claiming for emotional distress for every little thing that is part and parcel of life. If a student who suffers from stage fright is forced to give a speech in front of their entire school and they are suffering from emotional distress, should they be eligible to claim for IIED? What will then be considered an embarrassment in society? Despite everything, for anyone to claim damages, and in this case for Stephanie to claim, she must be suffering from a psychiatric illness that is recognized. If not, she's not eligible to claim at all. Thank you for listening to me.